Good morning, everyone, and welcome to our first public hearing of the 2019-20 term. We have a number of speakers endorsed to address us on 3 of the items on our agenda today. Some of you, I think, have been here before, and for those of you who have not, we allow 3 minutes. Sometimes we ask questions that extend beyond that, but if we don't, we like to stick to 3 minutes. And are looking forward to hearing what help you can give us on these particular items. So we'll start with item number 3, Administrative File 2018-02, a proposed amendment of MCR 3.501 to require that 50% of unclaimed class action funds be dispersed to the State Bar Foundation or otherwise as the court orders. And our first speaker is Bob Gillette on behalf of the Michigan State Planning Body today. Mr. Gillette.
Good morning, Chief Justice and Justices. May it please the court. The State Planning Body and the Legal Services Association of Michigan are the organizations that proposed this rule, and we also submitted fairly extensive written comments addressing some of Justice Markman's concerns. I'd like to briefly make 2 points and then take any questions. Over the past several years, the rules regulating cypre have been somewhat controversial, and I want to acknowledge that. But this proposed rule is not part of this controversy. The rule assumes the current system for managing class actions, which Justice Markman describes as reasonable and responsible in Michigan, and we agree, and adds a small footnote to the end of that process regarding the disposition of residual funds. On a national level, there's an organization called the Center for Class Action Fairness that has been involved in a series of cases challenging the historical cypre doctrine. These efforts were given some life by Chief Justice Roberts' statement in the Merrick versus Lane case. But that statement was made in conjunction with an order denying cert in a 2013 case. The claims that have really been raised asking questions about the overall cypre doctrine haven't really been adopted by any courts yet. Cypre is still fully viable in the federal system and most or all of our state systems. The proposed rule is based on existing law, and it provides guidance regarding the management of cypre funds. It provides that at the end of a class action, if there are residual funds, unless a more directly related organization is identified by the parties in the court, 50% of the funds go to the Michigan State Bar Foundation to enhance the state's access to justice activities. Someday, we acknowledge the Supreme Court or maybe Congress or maybe other bodies might weigh in and change cypre law, but that hasn't happened to date, even though it's been 6 years since the concurrence in the Merrick case, and the proposed rule doesn't affect that debate. It's just a small but helpful improvement to the current rule.
Mr. Gillette, as I understand the objections from the comments that we got, there are 2 separation of powers and perhaps a First Amendment Janus type complaint. And I understand those to be, from what you just said, you can't go yet because I'm still asking you a question. So those to be objections to cypre settlement arrangements generally. But and correct me if I'm wrong, I've never done class action litigation myself as a lawyer, but I understand right now these settlements happen in Michigan. Is that correct?
Yes. Again, more of the class action caseload and so more of the cypre activity is in the federal court system in Michigan, but they already exist as part of Michigan jurisprudence.
And right now, absent this rule, if there is going to be a cypre settlement, you can correct me if I'm botching the language, but it's up. We leave it to the lawyers, litigants, and the court as to who the settlement or the residual settlement goes to? Is that just the way it works now? I'm just trying to understand
Correct.
the status quo.
And all this says is unless the court and the parties identify a better, more directly related recipient, cypre is the next best thing, is kind of the translation, then the default is to at least 50% to the Bar Foundation.
So to play devil's advocate, it seems to me that by the court weighing in at all on how these settlements should be allocated, it could be viewed as the court putting its stamp of approval on the system more generally, and therefore weighing in a little bit on a dispute that may one day, as you say, be litigated in a court.
Well, the question is whether the court tries to improve the current system, which is the goal of this rule, or whether the court anticipates there might be some future change and acts, or doesn't act in kind of in reliance on things that might or might not happen someday in the future. Okay. The only other point that I wanted to make on the separation of powers issue is that neither of the comments that sort of raised that issue mentioned the case of Shady Grove Orthopedic Association versus Allstate Insurance Company, which is a U.S. Supreme Court case from 2013 with a lead opinion by Justice Scalia that essentially held that the class action rules are within the authority of the court to provide.
Okay, thank you very much.
Can
yes, of course.
Mr. Gillette, can I ask you a couple questions, please? The language of the proposed rule now says that unless the court otherwise determines not to distribute funds pursuant to some kind of CPRE determination, he must disperse all residual funds to a foundation or not-for-profit organization. Am I reading that too literally in thinking that suggests that in addition to the amount going to the State Bar Foundation, only one additional organization or foundation can be the recipient of funds? In other words, the use of the singular there can at least arguably be reasonably read to communicate that only one organization can be eligible for the residual funds. Is that
I do not believe
is that your
that
intention? Is that the rule's intention or not?
Not to my knowledge. I believe that courts have sometimes given residual funds to more than one organization, and it wasn't at least our intent to change that.
What do you think about the proposal, Mr. Gillette, of the city of Detroit essentially to exempt from the rule cases where the state or a political subdivision of the state is the defendant? Unlike private defendants, obviously, municipalities are funded by taxpayers for the good of the taxpayers, and rather than these funds going to organizations determined to be worthwhile organizations by the court, is there a reasonable argument to be made that those funds ought to go back to the taxpayer?
Well, I would argue, I'm not saying that's a totally irrational position, but I would argue that the purpose of a class action litigation is to provide some relief to some people who are injured in some way. And to the extent that the whole CPRE theory is to follow that damage award to a purpose that's most closely related to the purposes of the litigation, I don't support that exception.
So those organizations are as close to being injured as we can assume an organization is, right?
Well, and also, I mean, if it goes into the city's coffers, then it goes to the general purposes of the city, while, if, for example, a public safety damage award ended up going to an organization that was directly involved in programs and services that enhance public safety, that would be more direct than a general return to the city's coffers.
Let me also ask you a very informal question. You won't be bound by this. We won't write this in the rules in any way. But if a judge determines to allocate funds to a particular foundation or private organization, do you think there'd be an ethical problem with that judge sitting on a case involving that same organization a week later, a month later, a year later?
You know, to answer that a little indirectly, there's a number of cases discussed in the literature where cypres have been reviewed and reversed because of conflicts of interest, and I agree with the result in almost all of those cases. And so I think it's a case-by-case decision, you know, whether a particular judge in a particular case is too close. And there have clearly been some cases where judges have kind of, or counsel have kind of steered cypre, and that's a bad practice, and I oppose that. But I don't have a blanket answer to that.
But if I see a case wending up through the legal system that may involve Organization A, and Organization A seems to be one of those organizations that I might potentially channel funds to under the CPRE process, what would be the considerations I would give weight to in order to determine whether or not, on a case-by-case basis, as you say, this is one of those cases in which I better stay away from that allocation, or a case in which there really wouldn't be any particular conflict of interest? What would I look to?
Again, I'm not sure I can articulate a hard and fast rule. I think it is, you know, sometimes there is just one obvious organization or a very small handful of obvious organizations. And so I don't see a conflict, you know, I don't see a judge's connection to one of those organizations as being very troubling. On the other hand, the more broad the purpose is, then the more that could be some appearance that it's the judge's connection to that organization that influences the decision.
So would you favor an amended rule of professional conduct that would perhaps say very absolutely that to funnel funds to a particular organization through this process should not prevent a judge from subsequently sitting on a case involving that organization?
I guess I'd want to study that, but I wouldn't, off the top of my head, oppose that.
Would you oppose the opposite rule?
Yes.
Thank you.
Does the rule, the change you're proposing, prevent the parties from agreeing to return the residual funds to the defendant?
Not at all. You know, I've been involved in class actions that have done that. You know, it's part of the overall negotiation of the settlement of the case.
Because the rule doesn't seem to address that, because it says in matters where the claims process has been exhausted and residual funds remain, not less than 50% shall be dispersed to the Bar Foundation. So
Well, but it also says unless a different distribution is agreed on by the parties in the court.
Isn't that the next section?
I guess it's not clear to me that it says that, but you're not, that's allowed under current law, and you believe it should be allowed even under this rule change?
Exactly,
correct?
yes.
Okay.
Thank you.
Thank you very much.
Our next speaker on this same item is Thomas Lynn from Miller Canfield.
Good morning, Madam Chief Justice and Justice of the Court. My name is Tom Lynn. I'm an attorney at Miller Canfield, longtime attorney at Miller Canfield. In recent years, I've actually been quite involved with respect to legal service organizations and participating in legal clinics for low-income people. I'm here today to support adoption of the proposed rule or something close to it, and I would offer you 3 points. Mr. Gillette has stolen a little of my thunder, but the first point I'd make is there's a lot of the opposition seems to be associated with the cypre concept, and I think this is really a smaller rule than that. It really relates to what do you do with the residual funds at the end of a class action, and this is not really a major change. This isn't really pro or anti-cypre. Even if cypre awards, would be limited in some way, you still in class actions may have residual funds. So I think it really is not as big an issue, and we shouldn't get caught up in litigating cypre awards. Secondly, I would say this proposal has its origins in an action of the ABA House of Delegates that was adopted in 2016. Since it was adopted, almost half the states have adopted an amendment to a rule, or in some states, legislation that has accomplished something along these lines. And actually, to have half the states in the nation do something in 3 years is quite remarkable. I think, and if you look at the list of the states, there's a reference in the Miller-Canfield letter to the ABA site, and it lists the states, but it's quite a range of states. It's not coastal states, it's a bunch of Midwestern states and agricultural states. So I think a number of states have found an approach like this to be a positive change and have made that change. Thirdly, I would say designating the Michigan State Bar Foundation as a recipient of residual funds where no other charity is identifiable is consistent with the voluntary pro bono policies of the State Bar and this court and its designation of certain funds to the Michigan State Bar Foundation, for example, with IOLTA interest and certain filing fees. To me, no more important moral imperative for attorneys in our profession is giving meaning to equal justice under the law by supporting access to justice efforts and supporting the organizations that try to promote civil justice for those in our society who really can't afford it. This rule is a small gesture in that direction, giving more voice to the voiceless, and therefore I support it. Thank you very much.
Mr. Lynn, I'm less troubled by a result where the parties have some say. So a voluntary settlement, as some class actions, or maybe most of them, arrive at, where the parties have some say in the eventual disposition of the funds, as opposed to a case that's contested all the way until the end. Is there anything you can tell me that should make me less concerned about an involuntary provision in a judgment that requires the funds to be dispersed this way?
Well, as Mr. Gillette suggested, I don't think it's the intent that if there is a charity or a foundation or several that really are closely allied with the injury that sought to be remedied, that's not the case we're talking about. But in cases, we've all had this, we're part of a class action and we get a check for $1.06. And I think in class actions, there are, at the end of several years, there are funds left, and where do they go? And if it's a general injury, I think endorsing the idea that Michigan State Bar Foundation is an appropriate recipient of those funds, I think is salutary for our profession.
Do you have a sense of how many Michigan class actions in the Michigan courts resolve in a...
Relatively few. Most class actions actually are in the federal system.
But are resolved, of the fewer number that are in our state court system, the percentage that are resolved as part of a voluntary settlement versus class actions that are litigated to a final judgment?
I think I'm sort of in the same position as the Chief Justice, but my understanding is that most ultimately are settled prior to really full litigation. And the termination of residual funds is something that's part of the settlement process.
Thank you.
Thank you, Counsel.
Thank you very much.
Our next speaker on the same rule is Michael Pitt from Pitt McGee.
Chief Justice, good morning, Justice of the Court. My name is Michael Pitt, and I'm appearing on behalf of my firm. Our firm has been in existence about 27 years now, and we represent individuals in civil litigation for claims of negligence and claims, excuse me, against corporations and governments for wrongful conduct. I have taken class actions to trial. We've handled the appeals on class actions, and we've settled class actions. So I appear today as an experienced practitioner in class action
In your
litigation.
experience, what percentage of your class action cases are contested up to the point of a final judgment versus the percentage that are settled?
Well, we try cases, but they always end up in a settlement. I mean, if you try a case and it gets appealed and you're victorious on appeal, the end result, the allocation process is 100% of the time the result of negotiation. Courts don't impose upon the parties an allocation process. Because if you get the judgment on behalf of the class, the task then becomes how do you allocate the distribution of that aggregate settlement.
Sir, in your view, if this rule were limited to voluntary settlements, it would still include most, if not all, of the cases, at least that you've handled in your
Yeah.
career.
I mean, even the contested cases end up with a settlement at the end. There's no other way, because you have to come up with an allocation plan that allows everybody to participate on some equitable basis. So, in response to the question about the city of Detroit and maybe carving out a rule, part of the rule for governments, you really don't get to the side prey part of it, because the step before that is always whether or not there's going to be a reversion. And plaintiffs typically say no reversion. The money comes to the class or goes someplace else. Doesn't go back to the defendant. A defendant, though, can negotiate a reversion. So the state of Michigan or the city of Detroit can say, as a condition of the settlement, there has to be a reversion. So you
Or
don't even
a private corporation could do that, right?
we face that all the time. It becomes a hotly contested issue in negotiations, and there's horse trading that goes on to try to make the deal work, and sometimes you give up on reversion, sometimes you hold firm on it. It's all part of the negotiation process that goes on with class action litigation. I also want to share my views as immediate past president of Public Justice. Public Justice has been around 37 years. We have 22 lawyers headquartered in DC. We're a public interest law firm that seeks to establish public policy through litigation. A core principle of public justice is access to justice. And I have to tell you that public justice is the recipient of hundreds of thousands of dollars every year in side prey awards. There is quite a large industry out there in the federal court system. And our organization has been the beneficiary of very large awards. And as a result of those awards, we're able to hire attorneys, we're able to provide quality representation to indigent folks. We appear in all the circuit courts in the federal court. We have appeared in the Supreme Court. We have appeared before this body. We had 2 cases in the U.S. Supreme Court this year. So, the money is well spent at public justice. And I, as president, have had a lot of involvement in how to allocate those monies toward our programs to actually provide quality representation to people. I'll give you an example of a case we're working on right now. Many municipalities give to private companies the ability to collect fines from indigent folks for minor misdemeanor offenses. And these private companies put these folks into a death spiral. Many of these people end up losing their jobs because they become imprisoned because they can't pay these escalating fines. It's a serious problem. It's an access to justice issue. We have filed class actions around the country trying to prevent this, and we're winning those cases, and people are benefiting from that. It's a serious problem, and we're addressing it, and we're using cypre money to that effect. I have to also tell you that...
Mr. Pitt,
Yeah, I'm sorry.
would you, I had asked some questions of Mr. Gillette concerning some of the ethical considerations here. You would agree, would you not, that a judge who'd been responsible for channeling funds to the foundation that you've just identified would act questionably in participating in the case in which you were later litigating, I take it, wouldn't you?
I'm not sure I understood the question.
You indicated that your foundation was a major recipient of CPRE funds, is that correct?
Correct.
And then you indicated that you use those funds usefully and productively, I think you said, in later litigation.
Correct.
In that later litigation, would a judge properly be loath to participate in that case if he or she had presided in a case in which CPRE funds had gone in your direction?
You know, again, I think it's a case-by-case approach. I think the rule is, the whole cypre concept is being questioned. What I like about what the Supreme Court is proposing to do is it's regulating the cypre process. There's been a lot of criticism about cypre awards. Our organization is very concerned that some of the attacks on cypre could affect our ability to do the work that we do. I think having reasonable rules as proposed here would do that. And in terms of conflicts, there are conflicts that come up, but I don't think a judge per se should be disqualified from hearing a case that they may have awarded cypre to one of the parties or the other. I don't think that is a disqualifying event unless there's some stronger connection between the award and the matter that's before the court.
I'm interested in the point you just made because I'm probably as inexpert in this area as many of my colleagues. Most of my colleagues, I'm as inexpert. But you said there's been a lot of controversy about the process and that perhaps what's being done here is in response to some of those controversies.
I think so.
Can you just give me an illustration of
sure.
what those controversies are and what precisely the new rules would do to hopefully tamp down some of those controversies?
Sure. So in the world of class action litigation, we'll call them the mega cases, the opioid cases. These are large scale cases. There are objectors, we'll call them professional objectors, who appear at the end of the case and file objections for a lot of different reasons, some not very savory reasons, but they're out there. And one of the things they attack is the cypre portion of the settlement. And sometimes a judge will approve a cypre award to his or her law school, something that is close to them. And I think, judges are now being instructed, don't do that. The plaintiff's lawyers and the defense attorneys are not sending the money to their pet projects any longer, to their law schools, because the objectors are using that as a way to unravel complicated class actions because of the apparent conflict of interest.
I mean, what does this do to avoid the conflicts of interest, sending money to your own law school? What does this do to address and to ameliorate that problem? I'm just
because
not clear about that.
it's objective. The Supreme Court has spoken. The proper, as Bob said, the default position is to the State Bar Foundation and their efforts. It's neutral, it's clear, and there isn't any sense that we're manipulating the class action settlement to benefit some pet organization that the judges or the litigants have. And there's been criticism because litigants and courts have done that. And public justice wants a clean rule, a good rule, and we want to benefit from it. And if there are abuses, we want to bring them in. I think this proposal helps control some of the abuses that we have seen.
Am I wrong in saying that the abuses you've described are abuses as to which the rule is simply silent?
The rule is not silent. I think the rule is a proactive statement as to what this court believes is a proper avenue for a cypre award unless there's some indication that it's not appropriate. I mean, you know, the example that I gave in my letter was a consumer action for dog medications, and there's residual money left over, and so should the judge send the money to the foundation or should it go to a humane society? You know, I would think humane society might be a better selection in that case, and the rule, the way it's proposed, gives the judge that amount of discretion.
I don't want to beat a dead horse here. I understand your articulation of the problem. I'm still a little hard-pressed to understand what you see in the proposed rules that would ameliorate the problem, that address the problem. As I said a few moments ago, it seems to me that the major thrust of this is silence.
Well, but if an objector appears and raises an objection that money should not have gone to the State Bar Foundation, the answer is the Supreme Court has given us guidance and has told the court that's where it should go. And so you take out...
Some of it should go there.
Some of it. Some of it
perhaps
should
can
go
go to the same law schools that apparently you identified as having been problematic in the past, right?
That's right. And I think we all need to, we practitioners who do this kind of work need to be mindful that there are forces out there that want to undo class actions for a lot of different reasons. And we need to be careful because it is a terrific tool. People are benefited from it. My organization, Public Justice, has done terrific work in its 37 years, and we intend to keep on doing it. And cypre awards are a big part of making good things happen for people who need help. And so we want to do what we can to make sure that the class action model continues to work in a productive way. And I think this proposal helps meet those objectives.
Thank you.
Anybody else have any questions?
Thank you, Counsel. And our last speaker on this item is Tony Daunt from the Michigan Freedom Fund. Morning.
Good morning, Chief Justice, Justices. Thank you for the opportunity. I'm not an attorney, so I may come to regret this decision in about 3 minutes. But
What makes you think it'll take that long?
13 seconds in, I regret this. But Tony Daunt, I'm the executive director for a group called the Michigan Freedom Fund. It's a conservative advocacy group based here in Lansing. And we're supportive, obviously, of constitutional liberties for everybody, and believe that some of the things that the other speakers have talked about related to equal justice, making sure that those less fortunate have equal access as well as everybody else. We firmly believe in that. That's a principle everybody should be for. But that doesn't, because it's a good principle, doesn't change the fact that. As we've seen with the discussion thus far with among you and even those who support this, I think there's a pretty heavy amount of confusion still as to what this would do, what it would allow. And I think it brings in a significant concern of conflicts of interest for the judiciary, significant concerns of transparency, and basically turns the judiciary in many ways into appropriators of funds. And we expect those in the legislature who appropriate money to be subject to various issues related to transparency, related to conflict of interest, ethics. One of those tools is the Michigan Lobby Act. And in discussions with some legislators on this matter, they think, well, if the judiciary is going to be getting involved with distributing funds in this fashion, perhaps they should be subject to the Michigan Lobby Act as well. And so I think that all of this discussion about the rightness, the justice of providing equal access, understand that, but the judiciary, I don't think, is the right role. And as Justice Markman and others have pointed out in this discussion, the conflict of interest is real, and I don't think we need to be adding additional questions of people towards their government, whether that's the legislature, the executive, or the judiciary.
Mr. Daunt, when I read your letter, I read it as addressing a potential First Amendment question,
Yes.
a compelled speech question, but it seems like you're focusing more on the separation of powers.
Yes,
question.
I apologize. I thought I could make two separate
No,
points.
you absolutely can. I
Okay.
just wanted to make sure I'm like, and
Yes.
I appreciate the separation of powers question, and it sounds like it seems to me, from what I can tell, it's been litigated in a number of jurisdictions, and I have not identified any court who has yet agreed with that position, which isn't to say that someday a very important court could, in which case this whole discussion will be beside the point. But so far, no court has adopted that position that I am aware of. Are you aware of?
I'm not an attorney, so I don't pay that much attention to the various cases. I quite honestly don't even know what CPRE is
Okay.
in terms of getting to the root of it. But I look at it as a layman, as somebody who is active in holding government accountable. And
Understood. I just wanted to, given that the issue's actually been contested in a number of courts and no courts have signed off on it, it gives me some comfort. But let me move on to the compelled speech. Can you identify what it is? What is the speech that's compelled? Who's compelled to speak?
I believe when,
CPRE?
as I see it, when you're a class action member and the funds have not been claimed, and so it goes back and it goes to some other institution.
So it's the class member.
It's the class members, yes.
They weren't able to be found, so it's somebody who wasn't able to be found.
Or anybody.
My understanding of the doctrinal remedy for Janus was the opt-out provision. Why isn't the class action opt-out already addressing the Janus problem?
Well,
the doctrinal remedy seems to me built in the class action context, so.
That's a fair point, but again, as I'm looking at this, when you're a member of a class action, whether you're the individual who didn't come forward and the funds are being reverted, or you're somebody who has received some of those funds, by taking any of that money and giving it to a group, a cause that you may not agree with, that's compelling speech by taking funds that you were entitled to a portion of and making them subject to. And again, this may be an entirely worthy cause. It may be the Tony Daunt gets to go on vacation cause, but it's not an appropriate use of the funds from this lawsuit, and nor is it an appropriate role of the judiciary.
But do you see a difference between the Janus remedy, the Janus opt-out remedy, and the doctrinally, and the maybe that's not a fair question because you've said 4 times you're not a lawyer. So
I think I would
just
stand
trying
by
to
the previous comments on that one.
Fair enough. No, I take it back. I withdraw my question. Thank you very much. Does anyone have any further questions?
Right.
Thank you for coming. We appreciate your coming.
Thank you.
The next item is item number 4, which is the proposed amendments of the comments to Michigan Rule Professional Conduct 1.1 and 1.6 regarding lawyers' obligations to maintain competence in technology. And we have one speaker endorsed, Kimberly, am I going to botch this? Uhuru from the Attorney Grievance Commission. Good morning. Did I botch your name?
Good morning, Justice McCormick. No, you did very well with it. Thank you. Good morning, Justices. Thank you for the opportunity to address the court regarding proposed amendments to 1.1 and 1.6. The Attorney Grievance Commission supports both amendments and urges the court to adopt the proposed amendments as drafted. Regarding MRPC 1.1 and the duty of competence, we note that the proposed amendment is in line with the ABA model rule, which also includes a technology component related to competence. And with the adoption of this amendment, Michigan would join, I believe it's 36 other states that have included a reference to technology in their version of 1.1. We believe this component will only become more important as the profession continues to incorporate technology into the practice of law. Probably the most obvious example of this is the move toward mandatory e-filing in various Michigan courts. I can tell you, as a senior counsel at the Grievance Commission, It's not uncommon to see grievances result from lawyers who have not received the requisite training in these systems, and as a result, a client misses a filing deadline or motions not docketed because it's not properly filed according to the court's e-filing procedures. These are the types of gaps in competence that we believe might be cured or avoided if our rules of professional conduct specifically address technology. Other areas of concern include computerized legal research, the use of digital document and case management software, and even training and education around the use of social media. Although many attorneys will delegate the use of technology to non-lawyer staff, and I note that there was a letter filed opposing the amendment by an attorney who noted that he would just use secretaries or assistants who were competent in technology. That's really not a solution, because it's the lawyer's duty to represent clients competently, and that includes the duty to also supervise any non-lawyer staff. So simply relying on an assistant who's proficient in technology is not sufficient. The lawyer himself or herself needs to have a threshold level of proficiency. And we believe this amendment will help to serve the goal of protecting the public and the consumers of legal services. Regarding MRPC 1.6 and the confidentiality.
Let me just jump in, counsel, before you get to 1.6. Under 1.1, should the proficiency deal with just developing technology, or should it also include existing technology?
Well, I think a lawyer would have to be proficient in both, and I think the challenge to most practitioners is keeping up with the developing technology. I mean, I think most lawyers are using email and are using computerized case files and not just relying on paper files and using diary systems that are computerized and things like that. But we know that these things are always developing as hacking becomes an issue and things like that. You have to maintain competency in that. So regarding confidentiality and going to Justice Viviano's comment about developing technology, again, this is a proposed amendment that has already been adopted in some fashion by most states. We believe this proposal would urge lawyers to take additional steps toward protecting confidentiality and information. And these can include measures like use of encrypted email, use of virtual protected networks. It could be something as simple as making sure that the software that the law firm or the law office is using is regularly receiving security updates, is up to date. These are the types of advancing technology we would like to see lawyers become acquainted with and become familiar with. All of these steps would help lawyers to protect the information that they are storing for clients or sending to clients and third parties that must remain confidential already under 1.6. Again, we would urge the court to adopt both of the proposed amendments.
Thank you, counsel.
Thank you.
Our final item this morning is item number 7, proposed amendment to Michigan Court Rule 3.106 that would require trial courts to provide a copy of each court officer's bond to the Supreme Court Administrator's Office along with the list of court officers. And our first endorsed speaker is Cheryl Marie.
Thank you. Good morning.
Good morning.
I agree that a copy of the bond of a court-appointed officer should be sent to the state court administrative office. I suggest, though, a modification of the amendment should be considered. The existence of the requisite bond being made known should be accompanied by the existence of the pertaining oath of office, or it would be pointless for the court administrator to spend time assessing the bond's validity. If the bonded officer is not required to take his own oath, then the oath of the judicial officer who appointed that person would be the pertaining oath. I've viewed numerous oaths of office. They deviate from the wording commanded by the Michigan Constitution at Article 11, which I have here. That command is, quote, shall take and subscribe the following oath. Concerning the Michigan oath in that, Michigan Constitution in that oath, the prescribed wording shows the C of Constitution and the S of state in lowercase. The oaths I viewed show those words beginning with uppercase letters. The word this preceding the word state in the prescribed oath adds specificity, since the definition of bond, according to dictionary.com, is agreement or covenant, and the definition of oath is promise. Wording that deviates from the prescribed wording does not comply with the first essential of a valid agreement, which is notice. The deviation I've referenced begs the question, what state is this state when that word is shown with an uppercase S instead of a lowercase s in the oath? Therefore, I suggest that the amendment of this court rule should include the requirement that the pertaining constitutionally accurate oath of office be sent with the bond.
Thank you very much. Thank you
Anyways.
for coming.
Ms. Murray, are you a lawyer?
I'm sorry, I
Are
couldn't.
you a lawyer?
No, I'm concerned about law.
Well, I
And,
particularly,
particularly-
I want to congratulate you on the intense and the thorough analysis that you've given. It sounds like one of our court conferences. Thank you
you.
very much.
Thank you. I'm just concerned about people taking concern with evidence of authority. Thank you.
Thank you very much. Thank you for coming. And our final speaker is Court Officer Jeff Kirkpatrick. Good morning.
Chief Justice, Justices, I am the Vice President of the Michigan Court Officer Deputy Sheriff's Association and been a court officer for many, many years. And we oppose the court rule change. I'm not opposed to providing plaintiffs, for example, or defendants with access to the court officer's information, the bond carrier's information. But as I read this, it looks like it was going to be in a printed format. It seems like that's kind of counter to current technology. Several years ago, I served on an ad hoc committee appointed by this court, chaired by District Judge Brian Levy, which the end result of our work was the creation of Court Rule 3.106. And one of the byproducts of that court rule was this court required each district and circuit court to provide the State Court Administrator's Office with a list of court officers and to keep that list updated with the SCAO. Many courts complied, many did not. However, to the last speaker's point, every court officer that gets appointed has to provide the local court with a copy of their bond, and they have to, there's an agreement that they have to enter into, which was proposed as, again, the outcome of 3.106, so that information is readily available from the local court. In 2008, our association presented a proposal to this court's legal counsel for the registration of process servers in a manner very similar to the certified electronic recorders, to where there was some common place to track all of them. The idea being that every proof of service would require the process server or court officer serving the document to write their RPS number on each proof of service. When I presented this concept to Ann Boomer at that time, she said it was that she liked the idea, but it was something that the court, after research, was not interested in pursuing. Later in 2009, I attempted to accomplish this through legislation. So I had a bill ultimately drafted from the Legislative Service Bureau that created this registration process. And then in the political side of things, I was told at that time Governor Engler was not interested in more government regulation, so it didn't really go anywhere. But our association believes that a registry would help eliminate some of these ghost court officers. And I've personally been involved with the prosecution of process servers and court officers for bad service, embezzlement, and I heard the ding go. So I guess my recommendation would be to maybe include on the form a link to be able to find that information. And I would fully support that, but I think to hand it out doesn't make a lot of sense.
So just so I understand, you don't object to the providing of the bond, it's that it should be in a way that's electronically available?
Right, we have to provide it to the court in order to become a court officer to begin with, so.
Why not transmit it all electronically?
Yeah.
Yeah, that makes sense. Okay, thank you.
All right, thank you.
Thank you for coming.